Well, good evening, everybody, and a very warm welcome to everybody at this annual Media Law Lecture, which the Bonavero Institute always organizes in partnership with the Journal of Media Law. And I'd like to acknowledge one of the editors, Jake Rowbottom, who's been very involved in the organization of this, and some of the other editors, many of whom are far-flung in the Antipodes, for example, and so aren't able to be here today. But it is a partnership which the Bonavero values because of our focus on issues relating to freedom of speech. And we, many of you will know that one of our programs here is a global moot on media freedom and freedom of expression, which has the title the Munro E. Price Media Law Moot, and which is run every year with 7 regional rounds all over the world. And I'm pretty sure that online today we will have some of our mooters, so a very warm welcome to them as well. And finally, I would also like to welcome one of our newer program participants, and that is the participants in our massive open online course, which we partner with UNESCO on. It is on freedom of expression, access to information, and the safety of journalists. And it started running on Monday in 6 different languages and English. And it is 7 languages, Christos reminds me, 7 languages. We are delighted to say that we have more than 5,000 people registered for the MOOC. And once again, many of them are here online this evening. So a warm welcome to you as well. We're sorry that we're not going to see you in person at the Bonavero, but it's very nice to have you here. Just a word or two before I introduce our illustrious guest speaker, and that is about Professor Eric Barendt, after whom this lecture is named. Professor Barendt was one of the first legal academics in the United Kingdom to work on freedom of speech and media law, and many of you who will have first encountered, if you were UK law students, questions around freedom of expression and media law through his well-known textbook and writings. He also has a history here in Oxford. He started as a fellow at St. Catherine's College just down the road in 1971. And then in 1990, he moved to University College London, where he became the Goodman Professor of Media Law. During this time, he published widely, and including his legal book on freedom of speech, which I've already mentioned, and as well as a monograph on broadcasting law and a book on constitutional law. Professor Barendt is now retired, but he's remained prolific in his retirement, publishing numerous articles and books on academic freedom and anonymous speech. He was also one of the founders of the Journal of Media Law, one of our partners this evening. So it is in honor of his extraordinary contribution on freedom of speech that this lecture is named after him. We have had a range of very illustrious lecturers to give this lecture, and I'm really pleased this evening to be announcing the latest in that list, which is Professor Robert Spano, former president of the European Court of Human Rights. Professor Spano is a visiting professor here in the law faculty and a visiting fellow at Mansfield College, so we feel he's one of our community, and we're very honored that he accepted both those invitations to spend time here in Oxford. He is going to talk this evening on free speech and media pluralism. He is particularly well placed to do that, as having been the author of several important judgments during his tenure on the European Court of Human Rights. I would like you all to join me in welcoming Professor Spano.
Thank you very much indeed, Kate. Ladies and gentlemen, I would, of course, like to begin by thanking the Bonavero Institute of Human Rights, which I've had a partnership now for quite a number of years. It's been a great pleasure to take part in its growing reputation in the human rights field. The director, Kate O'Regan, of course, which is the catalyst for the progressiveness of the Institute. Thank you, Professor Rowbottom, as well, for inviting me to give this year's Eric Barendt Annual Media Law Lecture. In November last year, I concluded my 9-year term as a judge of the European Court of Human Rights, having had the fortune of serving as the court's president for the last 2.5 years of my mandate. Today, drawing on my experience as a judge and president of the court, I want to discuss the concept of media pluralism under the European Convention on Human Rights and recent developments in the court's jurisprudence, which I hope are of interest, in particular in the current multi-level, digitized and complex media environment. It is of importance that I begin with some disclosure. In my talk today, I will in large part discuss the Grand Chamber judgment in the case of NIT Srl versus the Republic of Moldova of 5 April 2022. I delivered this judgment as president of the court and was a member of the majority, which found no violation of the free speech provision of Article 10 of the Convention by a vote of 14-3. So therefore, my remarks have to be assessed and analyzed on this basis, but I'm going to try to be as objective as possible. I will proceed in 3 parts. First, I will discuss the concept of media pluralism from a theoretical perspective, drawing on the writings of Professor Barendt himself, as well as legal philosopher, the late Joseph Raz. I will discuss 2 questions in this first part. What does it mean to require pluralism of media content? And what does the answer tell us about the telos or the purposes of the right to freedom of expression in the European legal space? Secondly, I will turn to the case law of the European Court of Human Rights and discuss the findings of the court in the Grand Chamber judgment in NIT, to which I referred a moment ago. In particular, I will describe the court's exposition of the substantive principles and procedural safeguards which flow from Article 10 of the Convention when it comes to media pluralism. In particular, I wish to analyze the court's application of the concepts of external and internal pluralism, their internal nexus, interrelationship, and what conclusions can be drawn from the judgment on the current state of convention law for Europe's media environment. Thirdly, and to put the issue of media pluralism in its overall European context, including from the perspective of European Union law, I will briefly discuss the judgment of the General Court of the European Union in the case of RT France versus Council of 27 July 2022. In this judgment, the General Court upheld the Council's decision of 1st March 2022 to prohibit RT France, a Russian state-controlled news channel, from further broadcasting activities in the Union in the wake of Russia's invasion of Ukraine. The General Court relied heavily on the Strasbourg Court's analysis in NIT versus Moldova. Although a very difficult case, I will argue that the General Court's findings are in principle in harmony with the logic of the Strasbourg Court's view that the requirement of internal pluralism of the media is inherent in the way we Europeans conceive of the underlying values and purposes of freedom of expression. So now to my first part. In the 2nd edition of his seminal book, Freedom of Speech, Professor Barendt draws on Joseph Raz's writings and opines that, and I quote, freedom of speech reflects and reinforces pluralism, ensuring that different types of life are validated and promoting the self-esteem of those who follow a particular lifestyle. He explains that diversity of attitudes, moral beliefs, and ways of life exist in any developed or liberal society. Government must respect this diversity, as any attempt on its part to impose uniform standards of behavior may impose intolerable strains on social cohesion. He asks us to suppose that the principal media of expression are controlled by particular individuals or corporations, and that they deny members of minority groups the opportunity to express their views, to communicate with other people who share their way of life, or to persuade others to adopt it. He asks, should or may government intervene to promote freedom of expression in the interests of pluralism? He proceeds with contrasting the different conceptual approaches to media pluralism in the United States on the one hand, where it has been, as many of you know, met with skepticism in the US Supreme Court, and in Western Europe on the other, where there has historically been openness to the media being regulated to promote media pluralism, at least towards the end of the 20th century. He considers that the diverging approaches may be explained by whether we think of free speech exclusively in terms of individual rights and interests, or whether we also contemplate it as a public good or value in a pluralist society. He concludes that on balance, he prefers the view that free speech not only contains a set of rights, but reflects values which may on occasion require promotion through law. He continues by, however, making clear that commitment to free speech means that courts must scrutinize carefully any attempt by government to regulate its exercise, however well-intentioned that may appear. But an exclusive rights-based approach and a blind faith in the market also poses dangers, in particular that of a society in which only a few people can communicate their ideas effectively through the mass media. This is Professor Barendt speaking in 2005. Now, it seems to me that Professor Barendt correctly views media pluralism as drawing on a conceptual nexus with an institutional view of the right to freedom of expression. The free speech right is, in this sense, not only an individual right or a liberty inhibiting governmental interferences, which is the US constitutional conception, but also a public good, sometimes requiring proactive engagement by government to promote pluralism. If my assessment is right on Professor Barendt's views, it seems clear to me that he captures the essence of the European Court of Human Rights articulation of the concept of media pluralism in its current case law under Article 10 of the Convention. And this then brings me to my second part, explaining the concept of media pluralism under the European Convention. The current position under convention law is, as I mentioned at the outset, laid down in the Grand Chamber judgment in NIT Srl versus the Republic of Moldova of 5 April 2022. In brief, the facts were as follows. The applicant company, NIT, ran a TV news channel and alleged inter alia that the revocation by the Audiovisual Coordinating Council of the broadcasting license of its television channel of the same name had amounted to a violation of Article 10 of the Convention. Prior to the full revocation of its license, NIT had repeatedly been sanctioned for breaching Article 7 of the National Audiovisual Code, entitled Political and Social Balance and Pluralism. And this provision stated in its second paragraph, and I quote, "When giving airtime to a political party or movement for the propagation of its position, a broadcaster shall also give airtime to other political parties and movements within the same type of program and in the same time slot, without any unjustified delay and without favoring a certain party, regardless of the percentage of its parliamentary representation." At the outset, the court observed that NIT was not only contesting, among other things, the necessity of the revocation of the license, but also challenged the compatibility of this provision of the Code with Article 10 of the Convention. Therefore, the court considered that the negative obligation of the state not to interfere with free speech rights was linked to the question as to whether the state complied with its positive obligation to put in place a proper legal and administrative framework guaranteeing media pluralism. Now, allow me to immediately pause here to emphasize the importance of this conceptual starting point, for it demonstrates the dichotomy, I argue, the dichotomy I discussed a moment ago, between the individual rights-based approach to freedom of expression, limiting governmental interference on the one hand, and on the other, its institutional dimension, triggering a positive obligation of the state to promote pluralism by regulating the media. It is clear that the Strasbourg Court adopts, by articulating the purposes behind the right to freedom of expression expansively, the more holistic view, with the right encompassing both these negative and positive dimensions. This purpose-based or teleological approach in the interpretation of the Convention takes appropriately account of the Convention's historical genesis, originating as it does from the atrocities of the Second World War, as well as being alive to the way in which the Council of Europe has pursued its standard-setting work in the field in question for the last 30 or 40 years. In fact, in the field of media pluralism, the Council of Europe has been particularly active. In its judgment in the NIT case, the Strasbourg Court made clear that it was of some importance that the Moldovan audiovisual code had been scrutinized by experts of the Council of Europe during its drafting process and had been found, and I quote, commendable. Moreover, the court referred to the Committee of Ministers' recommendation of 2007, this is the Committee of Ministers of the Council of Europe, recommendation on media pluralism and diversity of media content. As I always explained in my speeches and lectures on the court, it is crucial to understand that the Strasbourg Court's interpretation and application of the Convention does not operate in a vacuum. Even though the Strasbourg Court is an independent judicial entity within the Council of Europe, it forms an integral part of the organism, which is the Council of Europe, along with its standard-setting work. And the NIT judgment is, I think, a very good example of the interplay between the two. Indeed, as the court reiterated in NIT, there can be no democracy without pluralism. Democracy thrives on freedom of expression. It is of the essence of democracy to allow diverse political programs to be proposed and debated, even those that call into question the way a state is currently organized, provided that they do not harm democracy. And this caveat is something that I will turn to later in my speech. In order to ensure true pluralism in the audiovisual sector in a democratic society, it is not sufficient to provide for the existence of several channels or the theoretical possibility for potential operators to access the audiovisual market. It is necessary, in addition, to allow effective access to the market so as to guarantee diversity of overall program content, reflecting as far as possible the variety of opinions encountered in the society at which the programs are aimed. The novelty of NIT versus Moldova resides in the fact that the judgment constitutes the court's first elaboration on the differing, although mutually complementary requirements of internal and external pluralism. External pluralism, that is, pluralism across multiple outlets, may be generated through the existence of various media channels, each expressing a different point of view, and is basically achieved by ensuring that the media are not concentrated in the hands of the few. Ownership control is the starting point of such pluralism, and it ensures that free speech is not diminished by the overbearing control of too few media entrepreneurs or too few actual media outlets. External pluralism in this sense had been, prior to NIT, the main focus point of the court's jurisprudence until the case was decided. Internal pluralism, on the other hand, which the NIT case was all about, concerns pluralism within a single media outlet and is another method of ensuring pluralism in the media. It relates to how social and political diversity are reflected in media content, that is, the representation of different cultural groups in the media, as well as divergent political or ideological opinions and viewpoints. Internal pluralism governance is a necessity in a media market marked by scarcity of frequencies, and its purpose is to compensate for that scarcity by imposing rules concerning diversity and fair journalism on each media outlet. Originating, as I do, from a country with approximately 375,000 people called Iceland, it's clear that for us in a country like Iceland, internal pluralism is even more important than external pluralism, simply by virtue of the fact that we will never have multiplicity of media outlets. And Moldova was a similar type of country, also for different reasons, which I will come to, which are historical, the issue that we dealt there with a country transitioning from an oppressive regime of the communist era. In NIT, the court was thus faced with a very far-reaching intrusion into the Moldovan media environment, with the full revocation of NIT's license to broadcast on its channel. This decision was based on previous findings, as I mentioned, of the National Audiovisual Authority that NIT had repeatedly breached the requirement of internal pluralism of viewpoints as required by Article 7 of the Audiovisual Code that I read aloud a moment ago. There were two particularly challenging issues in this case. The first was the articulation of the general principles under Article 10 of the Convention when it comes to a state's regulation of the balance of media content to secure the value of internal pluralism and its relationship with the court's existing case law on external pluralism. On this issue, the court took the view that neither the internal or the external should be considered in isolation from each other. On the contrary, the two aspects should be considered in combination. Thus, in a national licensing system involving a certain number of broadcasters with national coverage, what may be regarded as a lack of internal pluralism in the program offered by one broadcaster may be compensated for by the existence of effective external pluralism. However, it is not sufficient to provide for the existence of several channels. Or in other words, as the court states, pluralism of information and diversity of media content will not be automatically guaranteed by the multiplication of the means of communication offered to the public. What is required is to guarantee diversity of overall program content, reflecting as far as possible the variety of opinions encountered in the society at which the programs are aimed. The second challenging issue was the standard of review when it comes to the convention conformity of regulation limiting editorial freedom for the promotion of internal pluralism. It is clear that this is a very sensitive area when one looks at the core purpose of freedom of expression as a vehicle for open and often harsh debate in a democracy, including criticism directed at government. Hence, allowing government to regulate internal pluralism of a particular media outlet is not straightforward. Moreover, such regulation may, as in NIT, directly affect editorial freedom within the context of political debate. And the starting point had been, and still is under the Convention, that there is little scope under Article 10, Paragraph 2 of the Convention for restrictions on political speech or on debate on matters of public interest. In NIT, the court had therefore to take a position on whether the privileged position of the freedom of the press to report on political issues and other matters of public interest should mean that the strict scrutiny traditionally applicable to any restrictions imposed by the contracting states ought to limit correspondingly the state's discretion in determining the means of ensuring political pluralism in the area of licensing audiovisual media. The issue here, as often in the Strasbourg Court's jurisprudence, boiled down to the margin of appreciation to be afforded to the state. The court reiterated that given the multifaceted character and sheer complexity of issues concerning media pluralism, there are a variety of means that could be deployed by the contracting states to regulate effective pluralism in the audiovisual broadcasting sector. In such circumstances, the margin to be accorded should be wider than that normally afforded to restrictions on expression on matters of public interest or political opinion. The contracting state should in principle enjoy a wide discretion in their choice of the means to be deployed in order to ensure pluralism in the media. However, their discretion in this respect will be narrower depending on the nature and seriousness of any restriction on editorial freedom that the means thus chosen may entail. So, as often is the case with the Strasbourg Court, when it comes to the regulatory options, the framework analysis, the margin of appreciation of the state is wide in the choice of the means, but in the concrete application of the means chosen, there will be a gradual escalation of scrutiny depending on the level of intrusion in a case at hand. Goes without saying, when we're talking about the full revocation of a broadcasting license, the scrutiny will be strict. Overall, the court would have to be satisfied that the contents of the relevant national legal norms and their application in the concrete circumstances of a given case, seen as a whole, produced effects that were compatible with Article 10 guarantees and were attended by effective safeguards against arbitrariness and abuse. And in this connection, and this is an important point, as I will return to this, the fairness of proceedings and the procedural guarantees afforded would be factors which in some circumstances might have to be taken into account when assessing the proportionality of an interference with freedom of expression. So the way national audiovisual codes are formulated, the way in which procedures, for example, from audiovisual authorities like Ofcom in this country and others, how they are detailed in the regulatory environment are very important. On the facts, the court considered that the evidence, including recordings of the news bulletins, relied on by the national authorities in imposing sanctions on NIT demonstrated that for most of their duration, the news bulletins, which formed part of the monitoring proceedings, were devoted to political matters, and that the reporting was clearly biased in favor of the activities of the Party of the Communists of the Republic of Moldova and its members and supporters without providing anyone else with an opportunity to respond to the criticisms and attacks. The majority's finding of no violation of Article 10 was based on 4 important elements. First, the regulatory framework as such was in accordance with the overall policy put in place at national level to uphold the state's positive obligation to promote diversity of viewpoints in a country transitioning towards democracy. Second, NIT had been the subject of a gradual escalation of sanctions, with repeated warnings of breaches against the requirements of the national law and not immediate revocation of its broadcasting license. Thirdly, adequate procedural safeguards had been put in place for NIT to be sufficiently heard in advance and to be able to seek judicial review throughout the proceedings. And fourthly, considering the overall circumstances of the case, the revocation of the license was proportionate to the legitimate aims pursued. A minority of 3 judges, very good friends of mine, excellent people, dissented. Their disagreement stemmed at its core from their view that the judgment failed to provide sufficient guidance as to the conditions for subjecting a national broadcaster to the ultimate sanction of delicensing, what they referred to as the nuclear option, for supposed failures of internal pluralism, a consideration that will always retain a measure of subjective assessment by a regulator. In their view, delicensing on such grounds can be considered compatible with Article 10 only if the following minimum proportionality conditions are met. It should be based on findings of a sustained bias in the broadcaster's political coverage over an extended period of time. It should be preceded by a gradually increasing scale of sanctions, as well as a final warning prior to revocation of the license. And it should not be implemented in the absence of a demonstrated serious and imminent threat to major state interests, such as national security, without giving the broadcaster an opportunity to seek prompt judicial review and a stay of enforcement. In concluding this second part, it is my view, which is, I admit, not fully neutral, as I presided the Grand Chamber in this case, that the court took a very important step in the NIT judgment towards clarifying the convention standards on media pluralism under the convention. But I will be the first to admit more work needs to be done. The judgment should in no shape or form be read as providing a carte blanche to states to regulate the internal balance of content dissemination by the media. The judgment should be read to make clear that all such regulations will be subject of certain searching scrutiny by the court. However, context in the law, in particular in this area, matters, and what may be permissible and justified in one state will not necessarily pass muster in another. Moreover, under the European conception of free speech, regulators and judges are not agnostic on content, as is, however, the starting point in the United States, where the First Amendment requires, in principle, content-neutral regulations. Free speech cannot be used to advocate violence, hate speech, or propaganda, which at its core reflects a wish to destroy the fundamentals of democratic life. Therefore, in enacting laws and in enforcing them, national actors must be given flexibility to deal with the realities on the ground and to adapt their regulatory models accordingly. However, at all times, a strict approach to regulating media pluralism must be met with anxious scrutiny, and the burden is on the government to demonstrate that its actions are justified on the facts. Allow me then to finally turn to my third part. As I mentioned at the outset, the judgment in NIT versus Moldova was delivered in open court by your speaker here today on 5 April 2022. A month and a half had passed from the start of the war in Ukraine on 24 February. It was a truly difficult time in the court and in the Council of Europe in Strasbourg, a time I will never forget and have written about elsewhere. At the same time, another regional organization, the European Union, was dealing with the fallout of Russia's deplorable and aggressive actions, including in the field of media pluralism. On 1 March 2022, the Council of the European Union adopted a decision prohibiting RT France, the Russian state-controlled news channel, to broadcast further in the Union. As it was worded in the decision, the prohibition was to last until the aggression against Ukraine is put to an end and until the Russian Federation and its associated media outlets cease to conduct propaganda actions against the Union and its member states. RT France immediately brought an annulment action in the General Court of the European Union. The Grand Chamber of the Court gave judgment on 27 July 2022, upholding the Council's decision. The judgment of the General Court, which is now under appeal, by the way, correctly relied heavily on the case law of the Strasbourg Court, including the very then recently adopted judgment in NIT versus Moldova, as RT had supported its action inter alia on its right to freedom of expression under Article 11 of the Charter of Fundamental Rights of the European Union, the substance of which must be interpreted in the light of the case law of the Strasbourg Court as required under Article 52.3 of the Charter. I do not have time to analyze in depth the judgment of the General Court, which is very interesting in many respects, and I invite you to read it. I will limit myself before I conclude to 2 points. First, the RT case is all about internal pluralism of the media in the sense articulated in the Strasbourg Court's NIT judgment. The Council's decision to suspend RT France's broadcasting activities, effective immediately, was based on the content disseminated on the channel, which the Council determined as constituting continuous and concerted propaganda actions targeted at civil society in the Union and neighboring countries, gravely distorting and manipulating facts in order to justify and support the Russian Federation's aggression against Ukraine. Whilst it might have strengthened the reasoning somewhat had the General Court relied more explicitly on the concept of internal pluralism as elaborated in the NIT judgment, it seems clear that the close nexus between the content disseminated on the news channel and Russia's aggressive action were more than enough for the General Court to uphold the charter conformity of the Council's admittedly far-reaching decision, when seen from a pure free speech perspective. The second issue is to consider the claim made by RT France that it was not provided with sufficient procedural rights before the Council took its decision. Differently from the NIT case, where there had been a gradual escalation of sanctions before the decision to revoke its license, throughout which NIT had been afforded the opportunity to defend itself, in RT France, the Council took its decision with immediate effect without any prior warning. The General Court found, and I quote, that having regard to the quite exceptional context in which the contested acts were adopted, namely that of the outbreak of a war at the borders of the Union, the objective which they pursued and the effectiveness of the restrictive measures which they laid down, the EU authorities were not required to hear the applicant before initially placing its name on the lists at issue, and consequently that there was no breach of the applicant's right to be heard. I proceed on the basis that it may at least be arguable that this finding does not sit particularly well with the Grand Chamber's requirement in NIT on the existence of sufficient procedural safeguards in advance of a decision to revoke or suspend a broadcasting license. However, the law, and in particular human rights law, cannot develop in a vacuum, divorced from the realities of democratic life. Procedural rights are not absolute, as the General Court correctly asserts in its judgment. As I understand it, the Court's bottom line is that freedom of expression in the European legal space cannot meaningfully be invoked to sustain a claim for a media outlet to disseminate propaganda in support of aggressive warfare, which is anathema to the very foundations of the Charter and the Convention. Ladies and gentlemen, I now bring this lecture to a close. Freedom of expression is a fundamental prerequisite of what I have elsewhere termed the concept of inclusive democracy, which is embedded in the very fabric of the Convention, as Lady Hale and I discussed a few weeks ago. Correctly viewed, media pluralism as an institutional component of this freedom recognizes the transformative effect of the media for the development of life in a democracy. Everyone must have equal access to an expressive public forum. All viewpoints which do not promote violence, hate, or advocate illiberal forms of governance or outright lawlessness like aggressive warfare must have an outlet. There are multiple ways this can be achieved, in particular in today's digital and multi-level world of global communications. Professor Barendt opined as follows in 2005, and I quote, "The advent of the internet has perhaps weakened the case for media regulation to ensure that minorities and individuals can communicate effectively with each other. I'm afraid that this view, whilst fully reasonable at the time, was perhaps overly optimistic. We have already experienced the dangers of the internet when it comes to filter bubbles and echo chambers, where the use of algorithmic technologies has amplified potential imbalances in the overall dissemination of viewpoints. Regulation is still needed to fulfill the promise of freedom of expression and the concept of media pluralism. However, as with all regulations, a fact-sensitive and proportionate approach is what is required, not extremes and overreach. It is a delicate task to review the legality of governmental attempts to regulate the media. I can tell you this from extensive experience. We must be ever vigilant to strike the right balance. Thank you very much.